on this computer. Okay, and I'll hand it over to Michael.
Well, good morning, everyone. Can you hear me?
Yes.
Good. Well, I'm pleased to be with you here today and to share our mutual interest in writing. I became interested as a law professor about the time Scott Turow published 1L. And since we had both gone to Harvard Law School and he was a lawyer and a writer, I began to think, you know what, I was there too, and I saw all those things basically he saw, and I just never sat down to write about it. Anyway, it sparked the interest in me about writing. And like a lot of writers at that era, we all had a manuscript in our briefcases. And my interest started then, but it really didn't take off until I retired and moved down to Florida with my wife 11 years ago, when I really was able to write 2 novels, and I'm working on a third. So I wear 2 hats as a former law professor and lawyer and as a writer. And sometimes, as you know, the 2 worlds can collide. So that's why we're here today. I want to talk about legal issues that affect writers, basically 3 areas, because there's so many that could affect writers. Copyright, defamation, and right of privacy. I think it might be best after I conclude one of the sections, like copyright or defamation or right of privacy, we'll entertain questions related to that particular topic, then move on to the next. So that's one of the advantages, I think, of a group like this, that we can have more of a conversational dialogue. Copyright law, as you undoubtedly know, relates to promote works in progress under the Constitution. Effectively, it's a monopoly for a limited period of time in order to encourage creativity in the arts. It covers literary works, musical works, sound recordings, visual arts, and there's even an area where it overlaps a bit with patent law, which I'm not going to get into because my area was basically defamation and privacy, but inevitably I had to acquaint myself with copyright law. Now, the keystone now is the Copyright Act of 1978 with amendments, which provides that a copyright exists for the life of the creator plus 70 years. So it can involve, your heirs and live on after you. It's interesting. Some of you may have read in the press recently that the original copyright for Mickey Mouse in Steamboat Willie has expired. So now it's public domain. Anybody can do whatever they want with the image of Mickey Mouse. At least that image created in 1925, 1928. Yeah, 1928. At that time, there was a 95-year protection for copyrights. And over the years, there's been criticism that these periods have been a little too long. So now it's 70. So January 1st, Mickey Mouse is now fair game, at least the version of Steamboat Willie. Willie the Pooh came off copyright last year. And there's been some controversy because Winnie the Pooh has now been used in a slasher movie, I understand, or video, I'm not sure which, called Blood and Honey. And I can imagine the original creator just turning over in his or her grave, Now in Europe, they have something called moral rights of authors. We basically don't recognize in the United States. It says you have to respect the work of an author or a creator. But here we've got Winnie the Pooh that's now put in this very, I suppose, not cuddly aspect of being a slasher. So that's what happens, when the copyright expires, it's fair game. There are going to be a lot more coming up. I think Peter Pan comes up next year, and so we'll see more of these coming up. Now, in the public domain, then, it goes back to the public, which is the whole point of copyright law, to allow some lead time for the creator to reap some profits and then to open it up to the general public, the creativity. Now, a copyright can extend to compilations, periodicals, anthologies, and encyclopedias. So you have a separate copyright if you're the compiler of those. Of course, each of the contributors to that also has his or her own copyright. Now, practically all copyright cases now are not under common law in state courts, but in the federal courts. And under federal law, if you file in federal court, which generally has exclusive jurisdiction, as I mentioned, except some isolated cases that might still appear in state courts. The advantage is that there's a presumption of copyright ownership. Now, let me add that under the Copyright Act of 1978, the copyright comes into existence as soon as the work of art is created. Now, I remember very early growing up that it used to be you were only protected under common law copyright if you didn't publish it to a large group of people. And there were cases like, well, if a professor only publishes it to his class, is that opening it up to everyone? Does he or she lose their copyright? Well, that's all interesting history, because now you're automatically covered, whether you file a copyright registration or not. I got to admit, though, when I mail things out, I still put the little C on them. It's just habit. I don't know. I think it's psychological, but legally it's not necessary. It's not necessary. So if you also, however, if you do file, and there's every reason to file, register, not just rely on this unpublished copyright, because your goal is to try to have the world share in what you created. The advantage also registering is when you sue in federal court based on the registration, you are entitled as an alternative statutory damages or penalties, which can range from $750 to $150,000 for each violation, willful violation. Now, what's the advantage to new writers? It's this. As a new writer, I don't know about you, but some of my revenues from Amazon are like $1.78. I don't have a lot of profits. I'm not writing for profit, basically. I mean, because I enjoy it. So if I were to sue normally, I couldn't. What's the point? I can't recover much money in terms of my losses. And often the infringer doesn't have money either. So this is the advantage. You can require a substantial sum of money, even as a new writer, under the statutory alternative, under the Copyright Act. So that's another strong reason to register and to pursue any suit in federal court. Now, the work to be copyrighted must be, quote, fixed in a tangible medium of expression, unquote. And that's created a lot of litigation. For example, skywriting. I mean, you could write I suppose, a short story, maybe, I don't know, or a poem, but it's probably not going to be tangible or in a fixed medium sufficiently. So there could be controversy as to how fixed it has to be and how long. But that's the basic goal. Fixed in a tangible medium of expression, sufficiently permanent or stable to permit it to be perceived, reproduced, or otherwise communicated for more than a transitory period. Kind of vague, but that's where litigation happens. Now, it also must be by a human being, which seems obvious. But for example, one of the examples, I think it was an actual case, I'm not certain, an elephant that were to, with its trunk, create a drawing would not be protected because it wasn't a human being. Now, though, notice what's happening with AI, artificial intelligence. We're going to have a lot of litigation, because when I use artificial intelligence, and by the way, I've used it a bit in a novel I'm working on, I don't expect it to write the novel, but to brainstorm ideas, I've used it. The question then is, when I publish a work, or anybody else, is that the work of a human being or not? And I think there's going to be a lot of litigation about that. And I think part of it's going to depend on the extent to which you use it. Now, if the whole novel is ever written by artificial intelligence, maybe not. But I think at this point, I think for most people who use it, it's simply ancillary to their own creative endeavors. But that's going to be a big issue. Now, copyright, unlike a patent, does not have to be a novel expression. It has to be original. What's the difference? The difference is this. If I were theoretically to write a poem, maybe it's more realistic, that turns out to be exactly the poem written by somebody else, I have not infringed that copyright of the other person because it was original to me and I didn't literally copy it. Now, a patent's quite different. It has to be novel, whether or not I was aware of the other invention or not. So realistically, this doesn't come up very often because how often are you going to really create something exactly like somebody else created? The ideas, facts, and concepts are generally not copyrightable. Only the expression of those ideas, facts, and concepts. Now, this gets into, for example, words, generally short phrases, and titles are almost universally not copyrightable. There may be trademarks or something else, but not copyright. And I've gotten into that with my own works. I came out with a work called, the first one is The Mithras Conspiracy. It's a mystery thriller, history-based thriller, sort of a Dan Brownish kind of novel. Well, it turns out a week after I published it on Amazon, another book came out called The Mithra, M-I-T-H-R-A, not M-I-T-H-R-A-S. Those happen to be two alternate spellings for the ancient Roman god. So, I mean, I have no recourse, even if I wanted to. It turns out the book is completely different. It's a different kind of book. But there's no copyright protection I could get for the title. In fact, historically, a number of authors have generated profits, advertently or inadvertently, by using the same title of a more famous author. Now, it may seem a bit unfair, but generally not protected by copyright. Now, obviously, as the phrases get longer and longer, you get in the area of copyrightable material. For example, one example that's given is the phrase, quote, Madame Curie was born on November 7th, 1865. Well, there's certain long statements that are so factual in nature that they're of the type of fact that can only be expressed in one way. How many ways can you express the birth date of Marie Curie? So probably not copyrightable, because otherwise everyone would be hamstrung. They couldn't use a phrase because somebody else had used it. Charts, tables, and graphs are normally not copyrightable because they don't add any modicum of creativity. Now, you can play around with that. If I do a different kind of phone book that's not just listing names, it might be. But ordinarily, just listing charts, tables, and graphs are not. There was what's called derivative copyright. It's not just, if I write a novel, it's not just that. It's anything that arises from that copyright that could be copyrightable, such as a play, a movie, translation rights. All of those come within the bundle of rights of my original copyright. And that's why you get into the area of contracts. How much am I going to keep? How much am I going to license to other people? And you can split off all these different rights. One area that can be a defense is what's called a transformative work, where you take something that's already under copyright and you transform it into something, courts say, basically different. Satire and parody are classic cases where something is used in a way that was not intended, perhaps, by the original creator. Now that gets into a lot of controversy. At what point does it become transformative or just a bare attempt to try to gain a defense where there is no parody or satire? That's a matter of litigation in the close cases. Everyone, I think, here probably has heard of fair use, the fair use defense. Now, this is basically saying something that would be normally copyrightable is not because of a greater public interest in certain matters or certain situations. The fair use defense has 4 elements. These elements, once you go through them, are what you'd call factors that have to be weighed. They're not going to, it's not going to be like a calculator where you're going to come out and say, I consider the 4 elements, now I know it's definitely copyright defense or not. They're considered by judges and often by juries, if reasonable people could differ in how these factors apply. Now, let's go over the first factors. The first is the purpose of the use. So if I'm using something for educational purposes or non-commercial purposes, that's a very strong argument that I have a fair use defense because of the public interest. As a former professor, I relied on this a good deal of times. I mean, for example, I remember in our library, law professors would photograph copies of pages of books to give out to their class. Now, our librarian warned us you can't go too far with this. You know, using the whole book and just making a Xerox copy of a whole book, technically copyright violation. But because of the situation, educational, probably a very generous deference in terms if it ever came to litigation. The second factor to consider is the amount and substantiality of the part taken. Now, there's a case, and this gets again question of perception, how much is taken, and the proportion in relation to the total work. Good case was Google versus Oracle, where Google took only 0.4% of Oracle's code, of their computer code. And the court, there are other factors, of course, but the court said that strongly argues for our conclusion that Google did not violate the copyright of Oracle because they took such a minute portion. On the other hand, there was a book involving Harper and Row versus Nation magazine, where Nation magazine was found guilty of violating the copyright. I think Harper and Row had the interest in it because they used 300 words from a book that was 200,000 words. That seems very minor, but it could be. Well, the court said the problem here was that was the heart of the book, because it was a book about Gerald Ford's pardoning of Nixon and the reason he gave it. And that was the heart of the book, because that's what people wanted to know. Why did Gerald Ford pardon Nixon? So that case, that was an unusual case, because even though it was relatively small, objectively, 300 pages versus 200,000, it was so important to the book that the court said violation of copyright. Let's see. The amount, the effect of the taking. I thought I had another part here. Oh, the effect on the market. I'm sorry. The amount. The last one is the effect on the market for the original work. For example, I mean, if I do a book or one of your books or poems, you potentially have a market. Somebody might want to translate it for a European country. You might want you might want to make a movie out of it, a musical, who knows? So those are all potential markets that have to be considered in deciding whether a fair use defense applies. Have you interfered not just with the actual work, but its potential markets or its potential derivative uses, if you will? Example that occurs, for example, I think fairly often, is a movie will have the fleeting image of a book or a work of art. When almost invariably it's not considered worthy of certainly any litigation, because it has such a minimal effect on any potential use of the book or art. In fact, it may even increase it if it's in the movie. It may even increase sales for all we know. But those are the four factors basically that are considered. Any questions at this point on copyright? Because I don't want to get into all the woods, but just the basic issues. There's some that you've confronted. One I want to mention a few I've confronted, and then it might trigger some of your questions. One problem I had was a character. I had a character in my first book, The Mithras Conspiracy, where I wanted to name the main character was a police detective, Commissario Brindisi, Brindisi. It's a town in Italy, and I thought, well, his name came because he originally came from that town where there was a large population of individuals who were of Jewish background. His background that he was Jewish, although he was an Italian citizen. Well, it turns out that Daniel Silva, anyone, have you ever heard of Daniel Silva, who writes books in the more or less in my area, thrillers, I had a character, a cardinal called Brindisi. Now, I knew the law generally says that you can't get copyrights in a character, or because it's, for example, concepts are not protected, right? So if I'm going to do a novel about a cowboy, a heroic cowboy, no one can sue me for defamation because they did a novel about a heroic cowboy, because the court said that's what's called it's a generic type of movie, a scene affaire, F-A-I-R-E, guess it's the French term. It's just the thematic idea that's in common use. But so characters are generally not protected. However, if a character is specific enough and detailed enough and do all the things we say we should do as writers about characters, make them unique, some cases indicate it could be protected by copyright. Could be. So I didn't want to get into that area. I'm a lawyer, but I didn't want a lawsuit. I wanted to write. So I just changed the name to Marco Leone, L-E-O-N-E, a lion. Okay. But that's what I had to confront, in dealing with that issue. Anybody have any thoughts about copyright? Yes. Yeah. Martin?
Go ahead, Ed.
Okay, now can you hear me?
Yeah, I can hear you now. Okay.
Okay, I had a problem, and it was not actually a problem, and I don't think there's anything that anybody could do about it, but it happened, and it concerned me, and it's history now. But 30 years ago or so, I wrote about a half a dozen books dealing with marine aquariums and marine life. And they all sold pretty well. And those books were kind of the foundation for some of the marine aquarium work that progressed since then. And around that, maybe around 2010 or so, a guy wrote a book that wasn't really that great a book. And the name of the author of the book was Mo Martin. And my name is Martin Mo. And
oh, wow.
There was a lot of confusions, and that still shows up in Amazon under my name, that book. And I didn't do anything about it, but it did bother me. And I wonder, that could legally have been his name. I never found out for sure whether it was or not. But what?
Okay, you raise a good point. Because let's assume if it was legally his name, I suspect there probably would be no cause of action. But let's assume he adopted the name. It wasn't his real name. There is something we're going to get to, a right of privacy, called appropriation of a name, image, or likeness, which I think you might be able to use. We'll get to that later.
Okay.
It's a different court, but I don't think you're right. I don't think it'd be covered by copyright. But it's an interesting question. It just, I had an issue where I wanted to use a quotation from Nelson Algren about Chicago. My second book, Amazon Conspiracy, which is set in Chicago, involves Chicago characters, my native city. And there's a quotation, some of you may or may not recall it, where he compares Chicago to being in love with a woman with a broken nose. Okay, it's generated a lot of controversy for various reasons, but I thought, it'd be a provocative. Well, it turns out, that was under copyright, and I tried to contact whoever it was. They never responded. And I thought, again, it's probably maybe fair use, but on the other hand, I'm using it as a short phrase that sort of typifies the tone of the novel, maybe certain tone. And I didn't want to get involved with it. So I just let it go. But I heard from others that it's very difficult with some of these big companies getting permission. Because if you get permission, of course, you can't be sued for copyright. If you got a license. But it's very hard from these companies to do it, which I think forces people to, rely on fair use and other defenses. Okay, I'll move on if anybody else doesn't have a question.
There's some questions.
Oh, yes. I'm sorry. Ed.
Yeah, Michael. Early on when I was writing novels, I used to use lyrics from songs, 3 or 4 words out of a
Right,
song to
right.
as kind of like internal monologues, set moods and things like that. And I did that just injudiciously, not even considering the possible problems. Since then, I realized that songs, just about any part of it, you can't use, unlike say a written text from a poem or something like that, where you might quote something. So I successfully taken all those things out of there or modified them in such a way that they don't appear, I don't think, to infringe on anybody's copyright. So am I correct in that now that I really should have done that?
I'm glad you brought it up, Ed, because I had a similar experience. In my first novel, The Mithras Conspiracy, I wanted to use a song about mother, because the character is is involved in a terrorist act. And he doesn't know that his mother is in the piazza where he's going to set off the explosion. Then he finds out at the last minute. But anyway, I wanted to emphasize the strong relationship between him and his mother. Well, it turns out that it suddenly occurred to me, I was almost ready to send it out. I thought, you know what? This is a song. And maybe it's got a copyright in Italy or somewhere. I don't know. But I checked it out. I couldn't find any copyright. And what I did is I changed the words around, because I knew that you can't get a copyright in the word mama. So I just changed the words around a lot, and I didn't use an entire song. And that's the way I dealt with it. But you're right. There could potentially be a problem. Yeah, songs are protected. Correct. Not just because they're played. They can be copied by playing, but also by the lyrics. Yeah, right. It's a good question. Okay, no other question. Oh, yes, go ahead, Eileen.
Oh, okay.
Ginny,
Sorry.
did you have a
Oh,
question?
yeah.
You have a
Yes,
question?
I did.
I'm sorry.
Go
I
ahead,
thought-
Eileen.
No, go ahead.
Okay, so I have, I'm glad Ed brought up the thing about songs, and I knew that, and poetry also.
Right,
But there's a wonderful poet, Maggie Smith, who recently wrote a beautiful memoir. And I used a few of her just snippets as epigraphs in chapters of my book. And I tried to contact her, and I did not hear back. So I used them
Right.
anyway. My
Right.
publisher said nothing about it. The publisher seemed to think it would be fine. And I
Right.
keep worrying that Maggie Smith is going to, because we do travel in some of the same little circles.
Right,
And I'm so afraid that she'll see these and take issue with it.
right.
I used them because I admired her work so much. And one of the quotes, I mean, they're tiny little pieces of her writing. And I think I used 2 or 3 of them. Do you see that as being a problem?
Well, potentially. Now, the question is, of course, who owns the copyright? How much of her copyright did Maggie Smith give to her publisher? So first thing is to find out who you need to get permission from. If we're Maggie Smith and you knew her, that might be one way, but I suspect maybe the publisher has the copyright. Yeah, there could be a potential problem, which is the reason I didn't do it, because I didn't want that lingering.
Would my publisher
But
be
practically,
responsible for it, or would I be responsible for it?
for what? For taking the,
Would my publisher have been responsible for checking?
for giving you, if they gave you legal advice, they might be. If they, that's misrepresenting. That's another matter, potentially. But the real question is whether you would be. Potentially, it could be, but there would be the fair use. There's a fair use argument. Now, the question is, how important was that snippet to the book in relation to the entire book? And no one knows the complete answer, because it's a question that a trier of fact would have, because you're using it for commercial purposes, I assume, right? You hope to sell the book. So that's kind of a negative factor for use of fair use. You're taking only a small part, but it depends. It might be significant. But the other thing to keep in mind is this: there's the law, but there's other things besides the law. Hard for a lawyer to say, but it's true. For example, I think a lot of writers would be pleased because it gives more publicity to their work. But I didn't have that. I didn't have that opportunity with Nelson Algren. He's dead, even if I knew him. But one way, if you know the writer, is to go to the writer beforehand. And even if they don't have the copyright, they might be able to intercede on your behalf. That's the only I can suggest. But there's no easy answer, because there's no easy answer that says, no, you would definitely not be sued, or you could be. Just don't answer. The more you can take preventive measures, the better, in my opinion. Because as a writer, do you really want? Now, I was going to say, do you really want to be involved in a lawsuit? But part of me says, yeah, maybe you do, because sometimes when you get involved in a lawsuit, you really sell books. That's a perverse reality of the publishing world. So I'll leave that to you. Okay, defamation and privacy.
There was one more question from
Sure.
Jenny.
Two more questions.
Two more, that's fine. I have time if you do. I have time if you do. Bill?
Okay.
Well, go ahead, Jenny. Jenny's been trying.
Whatever's first. Oh, Bill?
Jenny, go ahead.
Oh, Jenny, go ahead.
My question is, when you copyright, do you have the ability to protect future film rights and future stage play rights?
Right. They're all within that bundle of rights you get. There's a bundle of rights, even though you're not using them at the time. Even though you're not using them at the time. Now, that's where we all wish we'd become, renowned, and then we have to hire an agent and a lawyer and to deal with all it. It's a very intricate area beyond my level of expertise. Drafting the contracts to decide what rights you want to keep, what rights you want to sell, what rights you might not want to sell, but license for a period of time. It's all a matter of contract law. It's all a matter of sitting down, negotiation, but you own the bundle of rights.
Okay.
Okay.
A neighbor of mine was the guy that wrote Lethal Weapon. And suddenly, when he saw the movie, he called the studios and said, that's my story. So he got 10% of the proceeds, and they produced.
He did. Oh.
So he's a rich guy. He moved from Teaneck and he moved up to wherever.
Wow.
But yeah.
Yeah, it's because a lot of times, of course, writers think it is, but it's just the concept. I thought of the hero riding off, the cowboy riding off in the sunset. Well, yeah, that's common. But I think, which is one reason why a lot of publishers will not accept unsolicited manuscripts. They don't want any imputation that they copied from what you did. So they won't do it at all. It's unfortunate, because I think, they're so careful that I think they make it more difficult for people that do have a good idea. But that's the reality of the marketplace. They don't want to take chances that somebody's going to claim you copied my work. Okay, any other? Yes. Bill?
Just a quick comment and a couple of yes or no questions too. But I did meet an author, along Eileen's point there. An author that was using Brad Pitt's image on her books, the cover, and she hoped she would be sued. She wanted to be sued so that it could be, more profitable for her. At least she.
Oh yeah, right. Anyway. That's why Brad Pitt might be upset.
Yeah, she wanted to meet Brad Pitt too. So
it's a good way to meet him in courtroom.
Then you listed some things that are covered by copyright laws, like anthologies and such like that. What about like newsletters? So we publish a monthly newsletter. Is that covered by copyright then as well? Or?
Yeah, sure. I mean, the people who wrote the articles have a copyright.
Okay.
Right.
And then you also listed things that are not covered. Like you mentioned charts and graphs and things like that.
Right.
What about spreadsheets? Are those covered by copyright?
I don't know. The quick answer is I don't know. I don't get into spreadsheets very often, to be honest with you. Okay. But okay, that spreadsheet. So the spreadsheet is really comprised of information contributed by number of people.
Correct.
Okay, I think it could be. I think my instinct. I don't know a definite answer to it, but because you have the spreadsheet, the person who puts the spreadsheet together is doing some creative work minimum.
I would think, yeah.
I would think my off the cuff answer is I would think so.
Okay.
Do you know of any actual case? I never have, but
No, but it's come up in conversation before, but I do
think
not have a case.
I think it would be. It's an interesting question. I think it would be, but that's my 2 cents.
Okay.
Okay, now defamation and privacy is the area that I taught in. In fact, defamation is what got me interested in constitutional law, because I had done tort law work as a lawyer, but then I started teaching it. But then New York Times versus Sullivan came out involving defamation of claimed defamation of public figures and public officials. And so I got more interested in that, and that led to just a whole interest in constitutional law, which I ended my career basically specializing, but being the main focus of my attention. But defamation and privacy are 2 areas that are basically what we call common law areas. That means they've been created by judges in the 50 states, often based on original English precedent. And the laws can differ and do differ. They're sometimes the common law is not all that common, but basically there is a thread that runs through it, so that I could pick up, as I have, a Florida case here to prepare for today, and I could understand and see how it relates to Illinois law or doesn't. There are more and more statutes that are passed by legislatures to try to correct or change the common law in all tort law, tort reform, if you will. And defamation's no different. There are certain statutes I'll mention, but basically it is still a common law cause of action, just as the right of privacy is. Which means for a lawyer that you simply can't go to a statute where all your answers are going to be. You have to do some research, find different cases. If you can't find them in your jurisdiction, look at other cases, because they could be persuasive, even though they're not controlling. Even though I can't find a Florida case, I can still use cases from other jurisdictions that might help persuade a Florida court to adopt or not adopt a view. Now, defamation, I think we all have a general idea, and that is a false statement which is published and harms the reputation of another in the eyes of a substantial and reputable part of the community. That phrase, I think, is from a Florida case, in fact. Substantial and reputable part of the community. Now, what is the reputable part of the community? Well, cases have come up where, for example, a person who is a thief sues because his reputation, I'll give you an example, reputation has been lowered in the eyes of the community of thieves because he's been called incompetent in his trade. Okay, that's just an example to show the court would just say discount it. So it has to be a law-abiding part of the community, because that's usually not going to be a big issue. But it has to be a significant part of the community, not the entire community. One person who believes it's defamation or hears it, probably not enough. But no one quite knows what's going to be significant. Normally, with modern mass media, it's not a problem anymore. It's going to be hundreds of people, at least, or 10 or 20. But it's usually not an issue, but it's more than one person to which it's communicated. And now with TV and radio, we had this problem. Slander was always something that was oral. Libel was in writing. Everything pretty much knows that. Now in modern law, it's basically combined. There's very, very little difference, and it's very subtle. I'm not going to get into all the permutations because it's not worth it. Some of it's really confusing, even to lawyers who practice in the area. But basically, it's been combined so that we say now that something can be libel to the extent it's worth making the distinction, not merely because it's in writing, but because it's widely broadcast in mass media. So TV, radio, probably the internet in most states is going to be considered, if it makes a difference, normally it doesn't, it's going to be considered libel, either in writing, permanent writing, or in a widely disseminated publication like mass media. Now, here's a classic case that came up to give you an idea of how we get defamation cases can be very colorful and very come up out of the woodwork. You never quite know. It's called Jews for Jesus case. I won't give you the citation. unless you're particularly interested in. It's a case where the defendant was a young man who was Jewish background, who had converted to Jews for Jesus, and he was now trying to convert his grandmother. And he did a newsletter, I forget what it was, or a newspaper. It was a newspaper article where he mentioned that his grandmother had converted, or implied that she had embraced the doctrines of Christianity. Well, she was indignant, sued for defamation. Now, the court, this is an interesting case because the court said, we know that some of these states like Illinois, I didn't mention Illinois, but some states have this newfangled tort called false light. Putting somebody in a false light is an invasion of privacy. We're not going to buy into that because that's what we have defamation for. I'll get into it later, but the Florida court has a good point. Why create something when you got an existing tort called defamation? And the court said it fits it. She has a right to sue because it put her it lowered her reputation in the eyes of those particular groups within the Jewish community. Doesn't have to be all the Jewish community, doesn't even have to be all the US. It's a substantial group. So that's how wide-ranging this thing can be. You know, and often that's why there are jury questions. What does it mean? What does it mean to say that you've been lowered in the eyes of the community? And it can reasonably be taken as interpretation. Now, in most states, including Florida, if a statement has two possible meanings, defamatory or not, it's left to the jury to decide which is the more likely that it was taken. Okay. Illinois, we used to have a rule that drove me crazy. It was called the innocent construction rule. And it said that if a statement can be taken in any way as innocent, it must be, in the case dismissed. We had a case where somebody called another a faggot. And the Illinois appellate court said, well, that could be a bundle of sticks. Well, everyone knows that there's another meaning to that in modern, of being gay. I mean, that's an example to my mind of how absurd it was. Now, the Illinois law has changed. It's modified it a bit. It's modified it, but has not completely abandoned it. Some like it because it protects freedom of speech more. And some would even say we should abolish defamation law and really protect speech. Well, society hasn't gone that far, and in my opinion, isn't likely to ever go that far. But in most cases, it winds up before the jury, because as long as reasonable people could differ, that's why we have juries, or a judge, if the judge is hearing the case. Now, Florida does have a statute that before you can file a suit against a newspaper, periodical, or other medium, you have to give them notice. And if the newspaper or mass media publication or other medium of publication, a broadcaster, had reason to believe, good grounds to believe the story was true, the only thing you can get is your damage. You can't get punitive. We have what are called three kinds of damages in defamation. Actual damage. The jury puts a price tag on how much my reputation was lost. Obviously, very subjective, obviously. But that's all I have to do is some rational argument. My reputation was lowered, put on some witnesses. The other is what's called punitive, where it was so bad we want to punish you, and the jury can impose money over and above the actual damages to punish. If they go too high, they can get into constitutional problems, but the Supreme Court is still allowed it. The last is that in certain cases of defamation, I'll get into a little later, you have to prove special damages. What is that? How's that different from actual? Special damages means dollars and cents loss. You have to show that you went to the psychiatrist and you had to get this kind of therapy because of the defamation. That's dollars and cents. And once you do that, then you can get your actual damages. But in most defamation cases, outside of a few we'll discuss, all you have to show are the actual damages. That there's loss to your reputation and the jury puts a price tag on it. With this case, all you can get against the newspaper is an injunction, or your actual damages. I'm sorry, actual. You can't get any punitive. You can't get anything else. Okay. Now it has to be false. In a pure opinion it can't create defamation because everyone's entitled to an opinion. It's free speech. But a false fact, now the difference between fact and opinion is really a tough area, because some things we thought were fact turn out to be false, such as like, the earth is flat maybe, or whatever, and some opinions vice versa. Now we get into a gray area called mixed opinions that could be defamatory. A mixed opinion was a case that came before the Supreme Court. Was the defendant accused the plaintiff of being a blackmailer and gave the facts on which the accusation was made. And the court said the fact that the facts were given so that the reader or hearer could make up his or her own mind means it really wasn't defamatory, the word blackmail, because it didn't imply facts that he had actually blackmailed in terms of a crime. Okay, so that's how subtle this can get. That a mixed opinion that contains facts may be defamatory, especially if those facts are left implied or aren't mentioned, sort of what you might call a half-truth. The truth is normally a defense in most cases. In fact, in certain cases involving New York Times versus Sullivan, public figures and public officials, it's an absolute defense. In other words, if a public official sues me, they have to prove that it's false. Otherwise, with private plaintiffs, some states like Florida and Illinois, they're a minority, but some of them, Florida and Illinois, say truth is only a defense if uttered for good motives. Good motives. Oh, wow, that opens the door. What's good motive? Well, if you can show that it was out of hateful or vengefulness, that's not a good motive, even though it was true. Now, I've often had a problem with this because it seems to me that that we have a branch of privacy law, that I'll get to, called publication of a private but true fact. So why do we need this new branch of privacy law then? If we have this good motives. But anyway, some states have that, but it only applies to private lawsuits. Public officials or public figures who sue for defamation, an ordinary citizen, have to prove actual malice, and they have to prove it was false. False. If it's true, the public official or public figure can't win. It must be published. Now, publication must be read or viewed by at least one other person than the plaintiff. Now, remember, it has to be defamatory according to a substantial view in the community. So you might have an expert say this is what the community would think. But as far as the actual lawsuit, only one other person has to hear it and believe it to be defamatory. Okay, now, so therefore, if you take something defamatory and you go directly to the person that you're accusing and tell them that's not defamation. It may be emotional distress, it may be any other thing, but it's not defamation. Somebody has to see or overhear the defamation. So the classic case, if you're in a room and you don't know that somebody else is in the room overhearing it, that's a close case. If I should foresee that that person would overhear it, it could be defamation. If the person pops out behind a curtain, I had no reason, probably not. Probably not. Okay, so it's false statement published to at least one other person. Now, when we get to public officials and public figures, you're probably familiar with this already from just watching the news. A public official or public figure has to prove actual malice, not just negligence, but that you intentionally or with reckless disregard of the truth published it. And it was false. Now, public figures are usually not a problem. We know we count the election, until recently, we just counted the election ballots, but we generally know they're certified. They're certified. What's a public figure? Well, the Supreme Court said there's some people that are general public figures. Everybody knows them. Cher, Johnny Carson, an earlier era. These are public figures. Everyone knows that. But you can be what's court said a limited one. You can inject yourself into a controversy. If you inject yourself into a controversy, you are putting yourself forward as a public figure. Now that can get tricky. What do I have if I get too involved in public affairs? Maybe if I later sue somebody for defamation, I'm going to have to prove more than I otherwise would have to prove. Okay, a good example was Mrs. Firestone. It arose out in Florida. She was of the Mrs. Firestone of the tire, who was an heiress of the tire fortune. She went through a messy divorce, and it got up to the Supreme Court, and they were trying to argue, at least the defendant, she was a public figure and therefore would have to prove actual malice, not just negligence, but intentional desire to defame or reckless disregard. The court said no, because she just was responding in press releases to charges that were being made to her. She didn't initiate them. The press came to her, and she was trying to maintain a sense of privacy, even though it was people knew about the controversy in Florida. So they could get very fuzzy. With public figures, usually it's pretty clear. But when you get into public figures, a little less clear. Now, damages. Okay, I'm going to simplify this because it gets really, depends on the jurisdiction. There's what's called defamation per se, defamation in itself, which on its face is defamatory. And then there's defamation, which is called by innuendo, or the Latin per, P-R, quote, Q-U-O-D. It's by innuendo. Now, what are the statements that if I say them and they fall into a certain category, considered automatically defamatory per se, which means that's good if you can do it, because it means damage is presumed. You don't have to prove actual damages even. It's presumed you're entitled to at least $1 or maybe more. It's presumed. You get the benefit of a presumption. These four categories in Florida, and they generally are pretty much the same all over the country, including Illinois, saying that someone or writing that someone committed a serious crime, felony, and often a sex crime, even though it's a misdemeanor, but a felony or a sex crime typically. And that's true of Florida too. Or saying that someone had a contagious, infectious, or loathsome disease. This comes out of the Middle Ages from England with leprosy, which is not a big issue. But now with AIDS crisis, we had a number of cases dealing with AIDS. Saying that a woman is unchaste. Now this is an interesting one, because I've often thought about this. Do we get into questions of, of stereotyping and gender issues? Because it only applies to females. And again, this goes back to our history, English common law, and it's in the Florida statute. We had a case in Florida here where it was a poem. Now, how many of you are poets or write poetry? Some of you. Okay, this was a poem. It was designed as satire of an official. Okay, I think it was before New York Times, so we didn't get into that higher standard. But the poem was a satire, but it referred to in one stanza as a hooker. It's a hooker. And the court said that imputes, or could be reasonably taken in the context of the poem, to impute unchastity to a woman, therefore damages presumed. She's automatically entitled to some money. Now, obviously, she's going to probably put on witnesses to get as much as she can, but whether she does or not, she's entitled to some money. Okay, so that's an example of a poem with one word. Now, you can't get a copyright on one word, but you can sure be the subject of a defamation lawsuit, because it's the worst kind of defamation because it falls into this category. The last category, the one that comes up most often, is saying something harmful or writing about it, a person's business, trade, or profession, because you're injuring their livelihood. Now, this gets tricky. For example, a sailor who curses a lot, probably, kind of our expectation. But if you said it of a minister, or that a minister was seen leaving a drug rehab house, quite a different matter, because it might well affect that particular trade. So those are the four categories where you have to be especially careful for. I just want to mention that. I'm not going to go into all the finer points. Now, it is possible to be sued for defamation by innuendo. Okay, an example, let's say you were to write, Sue, Tom's wife, had sexual relations with Bob. Well, that fits into category 1, saying that a person committed a serious crime, felony, or sex crime, adultery, assuming it's still on the books. That can vary the wording. Some states it has to be open and notorious before it's a crime. I don't know exactly what the Florida law is, but let's say that's considered a serious crime. That's per se. On the other hand, if the statement were Sue had sexual relations with Bob, could be her husband. So the only way I could prove defamation is by innuendo, by putting in facts that say, you know, that I was or was not Bob's husband. But in that case, most states, I don't have defamation per quad. I'm going to have to prove, before I can get any actual damage, any at all, what are called special damages. I'm going to have to prove some dollars and cents loss first, like seeing a psychiatrist, going to a doctor. Then I can get harm for loss of reputation. It's a very antiquated way of doing things, many different aspects. The law doesn't change here very often, and the courts seem uninterested in changing defamation law. But I suppose the original idea was that if you have to prove things indirectly, it doesn't damage you as much as if it's on its face in these categories. Broadly speaking, that's true. But on the other hand, you can think of cases where innuendo might be very harmful once it's brought to the court's attention how people understood it. Now, the defense is Florida has 2 years. Usually the defamation statute of limitations is short, 2 years. Illinois has 1 year. Now, one problem that came up in Illinois, and I don't know offhand how Florida would decide this. My brief research, I couldn't find any case. What if you don't discover the defamation until after 2 years or 1 year? I mean, you may be in Europe. How do you know? Well, Illinois adopted, and many states have what they call the discovery rule, that the statute only runs from the time you could reasonably have discovered the defamation and brought a lawsuit. Other states don't. They'll say, sorry, it's 2 years. If you didn't know about it, it's we don't want to encourage these lawsuits. But they're generally very short statutes. You cannot defame a dead person. So that's why writers and fiction writers, and even those who write supposedly nonfiction, could say whatever they want pretty much about the deceased, even though they might be sued for other things, but not defamation. Not defamation. The heirs of Al Capone tried to sue. The court said, no, because you're not the plaintiff. And Al Capone's dead. And it may reflect badly on you, but that's not a defamation lawsuit. Okay, they're called absolute privileges. If I go too long, just cut me off. But I just feel I want to be as complete as I can. I'm ending defamation soon. In order to allow the executive of a state or the federal government or the legislature or the courts of the states or federal government to operate, the officials in those positions have what are called absolute privileges. Now, I know there's another privilege coming up with Donald Trump. That's a constitutional privilege. This is different. This is not dealing with constitutional law. It's dealing with defamation. They may overlap a bit, but they're different. A judge can write an opinion that actually defames somebody. Can't be sued because the laws that's been handed down to us says it's better to give the judge freedom without worrying about lawsuits than about possible defamation. We had a case in Illinois where the governor of Illinois chewed out in a public press conference a company that bought mortgages and called them all kinds of names. Illinois Supreme Court said, well, that kind of relates to his duties of enforcing the law against price gougers or whatever, or slumlords. In fact, he called him a slumlord. So absolutely protected. Don't even go to trial. Lawyers are also protected for what they say in the courtroom. Absolutely. Now, when you get out of the courtroom, they might have what's called a conditional privilege. And we'll get into that. Legislatures, you probably know, are already protected even under state constitutions for what they say in the official capacity. So those, okay. Now, what's not as well known, is that there are conditional or qualified privileges that apply to everyone. So this says, even if you can prove a defamation suit against me, you prove everything, there's still a defense. And it's similar, all of you have heard of self-defense. You have self-defense, you can defend myself, I'm attacked. Well, this applies to defamation. There's a parallel structure here. For example, if I think somebody has run off with my van and I call the police, it turns out I'm wrong, can I be sued for defamation for making a false accusation? You could be sued. Maybe they can prove that it was a defamatory statement, accused them of serious crime. But on the other hand, if I did it in good faith, calling the police, courts will protect it. It'll be protected. You're protected. Or protecting the interest of another person, like self-defense of another person. The family, I find out that my aging parents are going to a doctor that I think is really substandard or is committing unethical acts. I'm protected because I'm trying to, as long as there's no showing of actual malice, of hatred, ill will, or some other motive that I have. If it's to protect my parents, I'm protected. Or I make a complaint to the HOA about somebody not painting their house the right color. Protected. Common interest. The one that's been pretty much superseded by New York Times versus Sullivan, but this comes to us all the way from England originally. Fair comment. Making a fair comment about public officials and the news newsworthy items. So this could still apply even though you're a private plaintiff. If you can show, for example, that I'm just reporting word for word, I didn't add anything, what happened. And this is called neutral reportage. In many states, I'm not sure Florida, to be honest with you, if you do this, you're generally, if there's no ulterior motive, you're generally protected, but not in all states, because the original defamation law said it doesn't matter whether you repeat the exact words. If they're defamatory, you've just added to the defamation, even though you're just repeating the exact words. So that's the real rigor of the law, unless it's been changed. That if I say something and I should foresee that other people will repeat it exactly the way I said it, not only can they be sued, but I'd be sued. Okay, so a number of states, though, have modified that. Some have said, as long as you repeat the exact words. Others have said, even if it's not the exact words, if it relates to a matter of public concern, you have a conditional privilege. And with public officials, of course, you're completely protected because they have to prove actual malice. Okay, anything about defamation before we conclude with privacy? Oh, one thing I want to say, excuse me, Harry. A lot of people think disclaimers are an absolute defense. I know I put in my book, and I think every writer does who writes fiction. This has no relation to persons living or dead, blah, 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 et cetera. Everyone's got a different boilerplate. I know my publisher had one, and I wanted to change it as a lawyer, probably tinkered around with it a little bit more. But the reality is, it is not an absolute defense. If people could look at that article and see that it relates to somebody in real life, you could still be sued. It's called Romana clef, for fiction writers. It's trying to disguise a real person in the guise of a fictional character. Now, it can't hurt, of course. It can't hurt. And I always do it because it could at least reduce the damages. In other words, I'm trying to tell the reader, if you could think this is taking to the actual person, I'm really not doing it. Now, whether that's true or not could be up to a jury, because sometimes it's pretty obvious that you're using a fig leaf to cover the person you're really talking about, a real person. But the disclaimer, just don't view it as an absolute defense. Okay, any thoughts on defamation? Yes, Harry. Harry, I can't hear you. I think he's got his voice off.
How's that?
Okay, I can hear you now.
That's got to be better. Thank you very much, Mike. It's been really informative and a lot to digest. And a lot of times it seems like doing your due diligence will avoid a lot of problems.
Right.
I write historical fictions, and a lot of them have to do with my ancestors. And I've demonized a couple of those deceased ancestors.
Well, they're dead, so they're fair game.
Pardon me? I'm sorry?
They're fair game if they're dead. They can't sue for defamation, nor can anyone sue on their behalf.
Well, that was a very comforting thing to hear you say.
Okay, now, yeah, what I will say this, I didn't find, I just did a brief survey of Florida statutes. I could not find any specific statute saying that it survives their death. I don't know of any state that it does. There's always that possibility. So this is not legal advice, but I would say that the general consensus is pretty overwhelming that it doesn't survive unless the legislature passes a statute, which I'm not aware. We haven't done that now. And the reason is most courts tend to be suspicious. I'm not hostile necessarily, but concerned about defamation lawsuits, especially going beyond the life of the person.
Yeah.
So I think you're pretty clear as far as I know.
Well, that's good news, Mike. Thank you.
Yeah, and how long have they been deceased?
For, let's see, probably close to 100 years.
Well, any statute of limitations would run out. I'm quite convinced. So I think you're.
There you go. Sounds good. Thanks.
Okay. Any other questions? Yes. Yes. Jenny.
You're on mute, Jenny. You're on mute.
Yes, I've decided to write my memoirs, and I've known in my lifetime quite a few well-known people.
Right.
That were friends, acquaintances, and I've got nothing bad to say about any of them, but would they take, I mean, you say you put Brad Pitt's thing on this, on a book, you know, you got a problem. I don't know whether I have to be careful with my my writing about them.
Well,
From a personal perspective.
I think you have to be careful. Now, how careful is the other question? Because you say, but you're going to write things that you don't think could be derogatory or reduce their reputation, right?
Right.
So actually, if that's true, I would think they'd be delighted because it's more publicity for them, you know.
Okay.
Do you know them well enough to contact them? I mean.
Well, a few of them, a couple of them had passed already.
Oh,
but,
well, then you don't have a problem there.
Well, I don't have a
Yes.
problem with that, but I'm still, there are still some living, so.
Okay,
But they
that
were
could be a
just
problem.
friends and acquaintances. It would just be personal experience with them as far as knowing them.
You know what I would do? I would try to talk to these people. I'll tell you why, because I haven't had it, but I've heard of other writers who use, well, it could be a nonfiction, it could be fiction. They use somebody in their writing who's related to them or a friend, and maybe they didn't even intend to, but the friend thinks they're in the book. But in your case, they are in the book, but they don't, what you see as favorable, they might not. That's what I'm saying. In other words, you think of favorable, and I'm going to get to a case under right of privacy that'll illustrate that beautifully. But because what you think is favorable, they might not. You know, people have different views of how they want to hold themselves out to the public. But I think you have to be cautious, and I think the better course would be to try to maybe have them take a look at it before you publish it.
Okay, thank you.
And if they differ and you differ and you're really strong about it, then it's a legal matter at that point. But I think a lot of these problems could be avoided if you do the actions beforehand before you publish it. Anything else?
Okay, thank you.
Yeah, right of privacy is the most interesting one because it's the most modern of torts. It did not exist really in the common law that came from the England and even in the States until former Justice Brandeis wrote an article co-authored it early 1900s about why we should have a right of privacy. And it's not in our Constitution. I mean, it's a matter of words. It's not expressly in the Constitution, at least. And so this is a very kind of, I guess you'd call it a modern concept, this notion that individuals have a zone of privacy. Now, what it means is really interesting. there was a well-known professor, now deceased, Professor William Prosser, who really was probably the most influential law professor in terms of trying to draw together our tort law across 50 states. And he wrote a treatise when I was in law school, it's still being used, that tried to do that. You know, what are the common elements? And how do these cases differ? And he grouped right of privacy cases, because the courts never had a philosophy where they had a philosophy and then they applied it. They just decided cases basis they came up. And he said these cases group into 4 categories, which most courts use now. It's called the first one is the intrusion into a zone of seclusion, probably what most of us think of privacy. You know, someone's area of privacy, like a peeping Tom. I mean, that should be protected. Okay, intrusion into a zone of, and what's a zone of, a reasonable zone of, again, it's a community standard, almost like defamation. What is considered a reasonable zone of privacy given our society as it exists now in this community? The other one is public disclosure of private but true facts. Now, it's not defamation because these are true facts, but there's some thinking that some facts are true, but the public has really no need to know about them. And the interest in privacy outweighs the public need to know these facts, often very personal. This is why states like Florida and Illinois kind of anticipated, in a way, this branch of privacy, because they said truth is only a defense with private plaintiffs if it's for good motives. In other words, in Illinois and Florida, theoretically, even if the statement is true, if it's false, if it's not a good motive, it's malice, it could be considered defamation. You know, even whether or not Florida recognizes this tort, but they do recognize it. So there's a kind of overlap. In a minority of states, there's an overlap. In most states, truth is an absolute defense for defamation. But this is saying no. So in many states, most states now have some privacy. Something might not be defamation, but it could be public disclosure of a private fact, even though it's true. It's not defamation because it's true, but it's a violation of this. The third one is putting another person in a false light in the public eye. Okay, this is the one Florida does not recognize. Our Florida Supreme Court, I think it was 2008, said, we have a perfectly good tort of defamation. We don't need another one. It's a useless tort. Some like this, and most states now have adopted it, because it's a way of doing an end run around some of the technicalities of defamation law that make little sense. And it has less of the baggage of defamation law. So Illinois, for example, recognizes putting another in a false light in the public eye. And now we'll get to how's that differ from defamation, because it's tricky. There may not be much difference. That's the problem. And the last one, which probably has nothing at all to do with privacy as we really think of it, is unconsented appropriation of a name, image, or likeness for a commercial benefit. Now you stop to think about it. Court started calling this a right of privacy. It has nothing to do with privacy. It's really more like a property right. In fact, more recent decisions refer to it as a right of publicity, because the person who has this right doesn't want to keep it private. They want to exploit it. They want to be able to make the money off it. They don't want you to do it unjustly. Okay, so those are the 4 basic branches. So let's go to the first one. It has to be a zone where you have a reasonable right of solitude, some call it, a reasonable zone of privacy. So normally when you're in the public eye, walking down the street, in a store, you don't have a zone of privacy. In fact, if you're caught up in a news story, there was a case in Florida where there was a robbery of a bank and somebody took a picture of the scene and one of the customers was there. And the court said, no, you're in the public place. It's just part of a news story. And therefore you weren't invaded. Your zone of privacy wasn't invaded. Now we had there was a case in Florida, 2003, where a secretary sued for what would now call a hostile workplace, complaining that there were inappropriate bodily touchings and comments made by her boss of a sexual nature. Okay, I mean, normally this would normally be at least common law battery case, touching somebody unlawfully. But for some reason, I'm not quite sure why, they wanted to sue for invasion of privacy. And the court said, no, invasion of a bodily part, if you will, touching somebody is not what we mean. We mean some transmission of information invading a zone of privacy. It's a quibble, really, because there are ways this woman could recover through a hostile workplace, federal statutes, or through battery, simple battery. Any unlawful touching you don't have to be black and blue. Any unlawful touching could be a battery if it's offensive. But it's an interesting thing. It only applies to information, basically, that's being circulated about you, where you're in an area where you should have a right of solitude, as the courts say. Publication of private facts, private but true facts. Now, this is the interesting one we don't recognize in Florida. But I want it comes up. But now, why do I bother bringing it up? Because when you're sued, let's say you publish something, you're sued. You could be sued in any state where it's published. So if you have the more successful your book, the more you're exposing yourself in a way, because it's going to be sold in 50 different states. And when they sue in that other state, they will apply typically the law of that state, which may be different than Florida. Okay, so that's why you have to keep this in mind. Case in Florida, where this comes up most commonly is a case where they call the "where are they now" cases, where somebody was in the public eye, they become very famous, and then something happens. They recede into the private area. And a reporter goes and says, "Where are they now?" The famous story occurred 1941, where there's a prodigy child who graduated Harvard at 16, was a professor at Harvard Law School. And then at 39, he was found living in a shabby surroundings, like in a very eccentric personality. They did a story. He sued and said, you're invading my privacy. I'm not just prodigy. I'm living my own private life. I'm trying to keep out of the public eye. I don't want publicity. The court in 41 said, well, once you're a public figure, basically, you're fair game. You can't recede back into privacy. This is hotly disputed. We don't have enough cases to be firm about this. For example, the European community, as I understand it, adopted a law that you cannot go back into a person's life once they've receded into an area of privacy. This is not necessarily true in the United States, at least based on this precedent. So that's an iffy area. At what point is it a private fact? Here's the classic case, though, in Florida. This is long ago, before we even adopted privacy in any state, let alone Florida. This was 1940. Well, this was 1944. I'm sorry, there was privacy at this point, but the court has this point about why it doesn't apply in this case. This was a case, I think you were mentioning, Ginny, about writing books about friends or people you know. This was a woman who was a good friend with the plaintiff originally, and she decided she's going to write a book about her colorful friend who had a lot of interesting eccentricities, but yet was a good person. And here's what she wrote. In 1930, my friend Zelma from the village was commissioned to take the census in the back country of Alachua County. Zena is an ageless spinster resembling an angry and efficient canary. She manages her orange grove and as much of the village and county as needs management or will submit. I cannot decide whether she should have been a man or a mother. She combines the more violent characteristics of both. And those who ask or accept her manifold ministrations think nothing of being cursed loudly at the very instant of being tenderly fed, clothed, nursed, or guided through their troubles. She was the logical census taker for our district. She knew all the inhabitants, black and white, and every road and trail leading to their houses. None of the places could be reached by the main road, and traveling by the automobile would leave most of the noses uncounted. She borrowed 2 horses from the manager of the packing house. and on a bright morning set out, and I quote her, "It's a blank," some curse words, "blessing for us. Not many Yankees have seen country like this, or they'd move in on us worse than Sherman," Selma said. Okay, Selma did not take kindly to this. She sued. Okay, the court said, this is a tough one because there's some things that are very favorable about Selma. She seems like a lovable person in her own way, but there's some things that are kind of crude, and they focused on the cursing. And the court said, we think that although there was some legitimate public interest, that it should go to trial, and she should at least get nominal damages. It could be $1, $10, whatever the jury thinks. Nominal damages are just to say, your rights have been violated, but so technical, we're not going to give you real actual damages, just nominal.
Okay.
The other end are punitive, where what you did was so bad, we're going to punish you. Okay, now the court said this, so I thought it was funny. It said there's a little problem here because Zelma sued for $100,000 for violation of her privacy and $100,000 for her share of profits from the book. And the court said, it seems odd that this woman wants privacy, but yet wants the profits from the book. Despite this, the court said, well, Selma's entitled to at least $1 or whatever. I thought it was an amusing thing. But it illustrates the problem. That just because you put some good facts in there, it's almost like the copyright cases. If a jury could find that those unfavorable but true facts outweigh the favorable, you could have a problem. It's an unusual case, but I bring it up to illustrate the point.
Yes, no, I appreciate it.
Yeah, the last one is really the right of publicity, although it's called privacy. I'm sorry, I'm the third one, putting a person in a false light. I'll take care of this very quickly. It really overlaps with defamation law, basically, except, no one's quite sure if it has all the defenses or whatever. I'm not going to get into that. But the problem is this: is there really a difference? I think there is in a very limited range of cases. For example, let's say somebody who's a private person is falsely claimed by a newspaper to be the hero of the year, to have gotten a Hero of the Year award for saving somebody's life. Mix up of the names maybe, and everybody starts calling this person. Well, I mean, the fact he was put in a false light. It's not defamatory because it's favorable. But on the other hand, I could imagine that this person would want to sue and say, okay, it's not defamatory, but I'm the kind of person, I don't want this publicity. I've strived to avoid this publicity. I'm a Salinger type. And you've put me in a false light. You may consider it favorable, but I don't. I think there may be, I think that would be the best kind of case for false light. So I think there's a reason for it, but a very narrow one. That's all I really want to say about it. It doesn't come up. It's certainly never going to come up in Florida because Florida doesn't recognize it. The last one, unconsented appropriation of a name, image, or likeness. This is a biggie because there's a lot riding on this because there's money involved. And this right of publicity basically started out as privacy. It's evolved in this situation, common law, now we have statutes, where the court said, if you appropriate my name or my image or my likeness and use it for a direct commercial gain, we think that violates a right. I think privacy is the wrong way to call it. It's what we would call unjust enrichment. You took something from me and you made a profit from it. I'm entitled to your profits. Or it's like a property right. Okay, just about every state has that now. And many states, including Florida and Illinois, have a statute. But even if a statute doesn't apply, you could still use the common law to the extent it's not covered by the statute. Now, an example of this was a newspaper showed the picture of an accident and a man was in a crowd. I remember I used that example before. It's an actual case. We analyzed that as a zone of privacy. But he also, as I recall, tried to raise the argument, well, you're making money. You sell newspapers and you're using my picture, so I should get something. Court said no. And the reason is because it has to be a direct commercial direct. There has to be a direct connection between taking your name, image, or likeness and my use of it. And the court said if they had used it in advertising their newspaper to get more subscribers, maybe. But this is part of a general news story. So this is why this won't work in most newsworthy stories. If it's newsworthy, it's a subject of public interest, you're not going to get anywhere, even though there might be some secondary monetary benefit to the person who's using it. Okay. But it comes up most often where we had a case in Illinois where it was a dog food, and it was the picture of a blind person that was used to sell this dog food, probably for seeing eye dogs. I don't recall. Person had an absolute case. You took my image, you used it not for a public purpose, but to make money directly connected to my image. Perfect case to get the profits and other damages. Now, the Florida statute, here's a good one. Florida. And I think somebody mentioned it before. They had a series of books they were writing. It might have been Martin, I'm not sure. Where this person did what he called the golden guides, books on various scientific topics. There'd be a series of books, and he had given consent for his name for 2 of the books, but not for subsequent ones. And the publisher said, wait a minute, you consented to the others. It's all one series. The court said, no, he has to give consent to each one of those. So although he gave consent to the first of the series, he didn't give consent to the 3rd book, and you needed to get his consent on that book. Okay, the Florida statute, which is where most of the action is now, it applies to deceased people. Okay, just the opposite of defamation. Just the opposite. It applies to deceased people as well as the living, where you need, and if the person's deceased, you need the consent of someone who has authority to consent to the use of their name, image, or likeness. And it has to be someone in Florida, quote, within the class of surviving spouse and children, unquote. Someone there who has the right. That may be a problem trying to figure it out, but that's a matter of probate law, who inherited it and whatnot. Okay. Now, for example, Marilyn Monroe, there's a whole cottage industry of lawyers protecting her image and revenues. And so famous people live on, and there's a whole industry that supports them and closely monitors the use of their images because their images is worth so much. I mean, realistically, somebody takes my image or an image of an ordinary citizen, even if they did it illegally, what is the real harm going to be? Is it worth suing? Well, that's the question you have to decide. Now the defenses are, well, you can get nominal damages and reasonable royalties. So the advantage of this tort is you can get not only damages for the harm that you suffered, medical bills, whatever, I don't know, but you can get reasonable royalties from what they did. So it could evolve to a lot of money, so that's why could be a suit that's very, very popular in terms of these 4 branches of privacy. The defenses are, if it's in Florida at least, publication of a bona fide news story or a presentation having legitimate public interest and not used for advertising. Well, that was always true, even in common law. A lot of times these statutes just summarize the common law. They don't always add something new. Secondly, the photo of a person solely as a member of the public and not named or otherwise identified in the use of the photo. Okay. Oh, here's what's new. There's a 40-year statute of limitations. So it exists for the life of the person, well, 40 years from the death of that person, at least in Florida. So you have a famous person in Florida, who's your famous person of choice in Florida. 40 years after the death of that person, you can freely use their image. Now, there's a case, I think I'm going to conclude my remarks. I've gone over time, I often did as a professor, unfortunately, or at least for the students. There's a case here, bring this home. There's a case in Florida called the Mardi Gras case involving a student who was, I think, a student at the University of Florida. She went to the Mardi Gras in Louisiana. And those things can get a little rowdy, Mardi Gras. Well, she was having a good time drinking and she exposed her breasts. And she exposed them to a group called Girls Gone Wild. I don't think they exist anymore. It was a group that went around videotaping college girls in risque situations. Okay. Well, she sued them, for unlawful taking of my image. And okay, now what the group did is they would sell these videos afterward. Okay, their defense was this is a subject of public interest. Mardi Gras is well known. It's a subject interest. You know what you're getting into. Too bad you can't win. What do you think happened? Anybody have any thoughts? If you were the plaintiff's lawyer?
She sued for exposure.
She exposed herself. But
Sure.
what's crucial? In other words, remember, a newspaper can't be sued just because they earn profit by running your picture as part of a news story with a crowd of people. But what was this company doing? Was it just doing a news story? No, it was selling these videos, and it had her picture. It had her picture on these videos that it was selling. The court said that's a direct connection, and therefore she should sue. Yes, can sue. Yes. I'm sorry. Yeah, Harry?
Well, I think it was probably just a big letdown.
Okay. Yeah. Now the court did say though in dictum is something we lawyers say it's not relevant to the decision, but it gives you an idea of the court's thinking. The court said if they had not advertised using her picture and sold it with her image on these videos, they might have been protected as a news story. It's a difference there. So basically, any questions on right of privacy or some courts, by the way, this is getting a little tricky because some courts have tried to expand it. Any likeness. Think of that. If somebody has a distinctive laugh and I take that laugh, but I don't show their picture or use their name, are they going to be able to sue me? Tune in. That's evolving law. Right now, most courts have said, let's keep it simple, image, name, or likeness. Any questions on privacy or any problems you've had? Yes.
I have a question. So it's interesting. I've seen this thing a lot, and I wonder if it pertains to this last piece. I call them page pirates, but for example, if you have a book that's out and then suddenly you find that there's a e-text version of that book using the same ISBN numbers, and it happens a lot. So it happened to me. So my book now has an e-text version for sale on Vital Source that costs more than my ebook. I can't imagine that anyone would buy it. It makes me feel like I've actually arrived to have it pirated like that. But do those laws apply to that? I've read different things, and it appears to be a very common thing now.
Okay, can you run that back? Okay, so your book is being pirated in the sense that it's appearing as an ebook?
It's appearing as it's called a textbook. And I haven't opened it, but it happens to a lot of writers now. So then suddenly their book with their same ISBN number and the same cover image is on another site being sold as a textbook. I can't imagine what's in it. I haven't looked inside, but the ISBN numbers are the same.
Oh, when you say the textbook, I'm thinking of a textbook that's used for schools. Is there a different meaning to it?
I don't know. It's listed as an e-text.
Well,
I could,
whatever it's called. If it's a copy and you're writing, yeah, it's a copyright violation. If you're assuming, it's a copyright violation. Now the question is, did you register your book with the Copyright Office?
I would assume my publisher did that.
Well, yeah. First thing you want to find out.
It says it's copyrighted. It says it in the beginning.
So maybe your publisher has the copyright and you don't. Is that possible?
I never gave it another thought.
Well, you might want to check into that because that's crucial. Who has the copyright? Now
And that's in the contract, I assume.
Yeah, you want to check that out. That's why the devil's in the details with these contracts. I haven't been fortunate enough to be in that situation where I have an agent who's going to do it. But I know enough about the law and contracts to know that you've really got to go over these and read them very carefully.
Well, so I'm looking and it does say copyright by me. So it says that in the front of the book.
Okay.
So
Okay, and you've given a license to your publisher to publish, obviously. So, yeah, okay, well, yeah, it sounds to me like if they're taking your text, given that what we're talking, it's more than just a fair use. Yeah, it's a copyright violation. And it seems to me it's in a relatively permanent form. I mean, an ebook is relatively permanent. It's not like skywriting. Anybody can call it. So yeah, it looks to me like you have a potential case there.
I would assume they're in China or something. So
could well be. And again,
yeah.
the question is, it's always a practical matter. What is it going to take to sue them? And what are the damages you're likely to get if you can find them and, serve them, bring them before a court? You're right.
Yeah, I wouldn't even attempt it. I'm just curious how it happens so frequently now. I see it a lot.
But if you could get statutory damages. Doesn't matter what losses you suffered or what profits they earned. Now, the problem is if they file for bankruptcy, you're back to where you started, even with statutory damages. Yeah, I didn't know that. I just thought it was curious that that some books seem to appear with similar titles right afterward. For example, my second book is called just American Conspiracy. I think a couple of weeks later, another book is called An American Conspiracy. It's a different book. I don't think there's any copywriting that I'm concerned about. But but you're right. I've often wondered how sometimes things appear right afterwards. And, and that raises the question whether some books are just being copied and who's checking to see if there is a copy. But like you say, a lot of it might be practical, the difficulty of suing. Yes.
Are book titles actually copyrighted?
No.
Yeah, you can use the same title. Yeah, that's what I thought.
Somebody could have called. In fact, this book, they call it The Myth Ra. And I have no idea why he did it, whether you knew about my now. All I know is it's an alternate spelling historically for this Roman god. But it doesn't matter because it's not copyrightable. Now there is something called trademark law, which I'm not going to get into. But if you can show that your symbol or logo was used for business purposes, you might. Now, I'm not sure. I don't know the answer. I don't think that normally a title of a book would be considered a trademark, but it might be, but you'd have to register it as a trademark. But as a copyright law, no, you're not going to do it. And by the way, there was an article, I wish I'd clipped it out. I think it might have the Wall Street Journal years ago, that historically there have been writers who appears with some intent have used a book, used the title of a famous author. And no one quite knows, of course, how much of funds are siphoned off to people who mistakenly think they're getting the popular author and are getting an author who's just using the same title. But there are books with the same title, I think, even on Amazon. And I don't know, it seems to me that is unfair, but no one seems to want to handle it, at least right now. Well, it's been a pleasure being with you all, and happy writing. And I know I don't know about you, but I suspect we're all in here not because we're going to make $1 million, although that wouldn't be bad. It's because we enjoy doing it. And good luck in your writing.
Yeah, thank you, Mike.
Take care.
Thank you for coming. It was
Bye-bye.
very
Yeah,
informative.
thank you so much.
Very interesting.
Thank you.
Bye.
Bye. Thank you.
Bye-bye.
I guess he had to go. Oh, all right. Well,
Yeah,
I
I'm
guess that
still on.
brings,
I don't.
our meeting to a conclusion here. Thank you, Gloria, for setting that up for us. A very interesting talk and a lot of information there. And he had, I think, more questions than he bargained on from us, right? So
I actually had a list of 4 that I never got to. So
yeah. Well, maybe we can email him or something. I have some
Yeah.
questions too. But
okay.
thank you, everybody, for showing up. Appreciate it. And we'll see you again soon.
All right. Take care,
Yeah.
everyone. Bye.
Yeah, take
Bye.
care, everyone. Bye.